A residence trust, commonly known as a Qualified Personal Residence Trust, QPRT, is an estate planning strategy used primarily to minimize federal estate taxes by removing a primary or secondary residence from an individual's taxable estate. It allows individuals to transfer ownership of their home or vacation property into a trust while still retaining the right to live in or use the property for a specified period. This video will go over the details of establishing a QPRT, including its benefits, drawbacks, and step-by-step process. Setting up a residence trust, step-by-step guide. 1. Choose a qualified property. A QPRT can include a primary residence or a vacation home. It cannot contain investment properties or rental properties used to generate income. The home must primarily serve as a personal residence to qualify. 2. Select a term length. The grantor, or person creating the trust, must select a term for the trust, typically between 10 and 20 years. During this period, the grantor retains the right to live in or use the property rent-free. If the grantor outlives the trust term, the home is transferred to beneficiaries at a reduced tax value. However, if the grantor passes away before the term ends, the home reverts to their estate. 3. Transfer the property into the trust. Legal ownership of the property is transferred to the QPRT, removing it from the grantor's taxable estate. However, this action triggers the gift tax, and the value of the gift is calculated as the present value of the property's future interest. 4. Appoint trustees and beneficiaries. The grantor appoints a trustee to manage the property within the trust and chooses beneficiaries who will eventually inherit the home. Trustees are often family members or trusted advisors. 5. Pay gift tax, if applicable. Transferring the property into the QPRT can trigger gift tax liability. However, the value of the gift is based on the IRS valuation method, often lowering the taxable value due to the property's future interest. 6. Occupy the home. During the trust term. During the trust term, the grantor can continue to live in the residence without paying rent. They also retain the responsibility for the property's upkeep, maintenance, insurance, and property taxes. 7. End of the trust term. When the trust term expires, ownership of the property is transferred to the beneficiaries, or it can be placed in another trust. The grantor may continue to reside in the property after the term ends, but they may need to pay rent to the beneficiaries if they wish to remain. Pros of setting up a residence trust. 1. Estate tax savings. One of the primary advantages of a QPRT is that it helps reduce federal estate taxes. By transferring the home to a trust, the grantor removes it from their estate, decreasing the estate's total taxable value. 2. Reduction in gift tax value. The gift tax is based on the home's present value, which can be significantly lower than its fair market value due to the retained interest over the trust term. This makes the transfer more affordable from a gift tax perspective. 3. Future appreciation, excluded from taxable estate. The home's value, including future appreciation, is excluded from the grantor's taxable estate once it's in a QPRT. This can significantly reduce estate taxes, particularly if the property is in a location with high appreciation rates. 4. Asset protection. A QPRT offers a level of protection from creditors since the property is technically owned by the trust and not by the grantor. However, this may vary depending on state laws and other factors. 5. Beneficiary inheritance benefits. The beneficiaries of a QPRT receive the property with minimal estate tax liability, depending on how much of the unified credit the grantor has used. This can be particularly advantageous if the trust property is highly valuable. 6. Allows for continued use. The grantor retains the right to live in the home rent-free during the trust term, making it a feasible option for those who wish to enjoy their home while reducing their taxable estate. Cons of setting up a residence trust. 1. Risk of grantor's premature death. If the grantor dies before the trust term expires, the property's ownership reverts to their estate, negating potential tax benefits. In this case, the home is treated as part of the taxable estate, and estate taxes may apply. 2. Gift tax exposure. Although the QPRT can reduce the value of the gift for tax purposes, transferring a valuable home into the trust could still trigger significant gift tax depending on the unified credit amount already used. 3. Irrevocability of the trust. A QPRT is irrevocable, meaning the grantor cannot change its terms, terminate it, or reclaim the property once it is transferred into the trust. This lack of flexibility can be a drawback for those who might want to change their estate plan in the future. 4. Possible rent payments after term expiration. If the grantor wishes to continue living in the home after the trust term ends, they must pay rent to the beneficiaries. This rent is not tax deductible, and it can be a financial strain, particularly if the property's rental value is high. 5. Risk of property value decline. If the property's value decreases over the trust term, the beneficiaries receive a devalued asset. This may reduce the potential benefits of creating a QPRT, especially if appreciation was a primary motivation. 6. Complicated setup and maintenance. Establishing a QPRT involves complex legal procedures, ongoing maintenance, and administrative costs. Grantors must consider attorney fees, trustee fees, and the cost of tax compliance. Regular upkeep expenses are also the grantor's responsibility during the trust term. 7. Potential capital gains tax for beneficiaries. If beneficiaries sell the property after inheriting it, they might face capital gains tax based on the home's appreciation from the date of trust formation. The stepped-up basis, usually available for inherited property, is not applicable in QPRTs, potentially leading to higher tax exposure for beneficiaries. Considerations before creating a residence trust. 1. Life expectancy and health. Since the trust's benefits depend on the grantor surviving the trust term, age and health should be considered. A QPRT might not be the best fit for older individuals or those with serious health issues. 2. Market conditions. If the property is in an area with unpredictable market trends, the QPRT could have unintended consequences. For example, a home in a depreciating market may not provide the intended tax savings, while a highly appreciating asset may offer more benefits. 3. Family circumstances and beneficiaries' needs. It's essential to consider family dynamics. Beneficiaries should ideally be financially capable of managing the property if the grantor needs to pay rent or vacate it after the trust term. 4. Consultation with an estate planning expert. QPRTs involve intricate legal and tax considerations that require specialized expertise. Consulting with a knowledgeable estate planning attorney or tax advisor is crucial to understanding the suitability of a QPRT within an individual's broader estate plan. 5. Additional costs and administration. There are several administrative costs associated with setting up a QPRT, including legal fees and trustee fees, as well as the cost of tax compliance. Further, the grantor is responsible for maintaining the home, paying property taxes, and covering insurance during the trust term. 6. State-specific regulations and tax implications. States have varying regulations that could impact the effectiveness of a QPRT. It's essential to consult an estate planner familiar with state laws to determine how they might affect the trust's viability and cost-effectiveness. Can you refinance a home? When it is in residence trust, yes, it's possible to refinance a home that has been placed in a residence trust, QPRT, but the process can be more complex than a standard refinance. Here's an overview of how it works, the challenges involved, and important factors to consider. How refinancing works with a residence trust. To refinance a home in a QPRT, the lender typically requires that the property be temporarily removed from the trust. This temporary removal is called deeding out of the trust. Here's the basic process. 1. Deed out the property. The home is transferred from the trust back to the grantor, the original property owner. 2. Apply for refinance. Once the property is back in the grantor's name, they can apply for a refinance loan. The grantor must meet the lender's credit and income requirements to qualify. 3. Complete the refinance process. After meeting the lender's requirements and closing the refinance, the loan terms are finalized. 4. Transfer the property back into the QPRT. Once the refinance is completed, the property can be transferred back into the residence trust to preserve the estate planning benefits. Challenges and considerations. Refinancing a home in a QPRT presents some unique challenges. 1. Lender requirements. Not all lenders are familiar with or willing to work with homes in QPRTs. The process of transferring property in and out of the trust can be complex, and lenders may perceive additional risk. This could limit options for finding a mortgage provider. 2. Legal and tax considerations. Deeding the property in and out of the trust could have legal and tax implications. To avoid any unintended consequences, consult with an estate planning attorney or tax advisor. 3. Potential fees and administrative steps. There may be costs involved in transferring the deed out of the QPRT, closing fees for the new loan, and potential legal fees. These expenses should be factored into any refinancing decision. 4. Consent from beneficiaries. In some cases, the trust may require consent from beneficiaries to make changes that affect trust assets, such as refinancing. Review the trust's terms to understand any specific rules that may apply. 5. Ongoing compliance. After refinancing, ensure that the trust remains in compliance with all IRS requirements to maintain its QPRT status. An improperly restructured trust could lose its estate tax benefits. Final thoughts. Refinancing a home in a residence trust can offer benefits, like lower interest rates or better loan terms. But it requires careful planning and guidance from both financial and legal professionals. It's essential to ensure the process aligns with the trust's goals and preserves its estate planning benefits. Final thoughts. A residence trust can offer significant tax advantages for those looking to reduce the value of their estate and transfer valuable real estate assets to heirs. However, it requires careful consideration of factors such as trust term, property appreciation potential, and the grantor's health. Consulting with an experienced estate planning professional and understanding the commitment involved are essential steps to maximize the benefits of a QPRT. When deciding whether to establish a QPRT, weigh both the benefits and drawbacks in the context of personal circumstances, estate goals, and financial standing. Thanks for watching. Please subscribe.